Okay, this is file 22-21082-FC, People versus Count Teresa the Almighty Trevino. We are here for a resentencing in this case, and we are proceeding today in person. First, can I have the attorneys place their appearance on the record, beginning with Ms. Wise.
Good morning, Your Honor. Jackie Wise and Doug Hartung on behalf of the people.
And good morning, Your Honor. Jason Snyder from the State Appellate Defender Office on behalf of Mr. Trevino, who's seated to my right, to my left.
All right, and so you are Count Teresa the Almighty Trevino?
Yes.
Mr. Trevino, have you had an opportunity to read and review your updated pre-sentence report?
No. Yeah, neat.
We did last time.
Yeah, you told me nothing changed, so yeah, there's no need.
Yeah.
Have you received a copy of that report?
No, not yet.
I mean, I have reviewed this with them, Your Honor. I can show him again. The report is identical except for the cover page that I showed him before. So
Yeah, I've already reviewed it that way. Yeah, I don't need to see it here.
yeah.
All right, so you're entitled by law to have a copy of the pre-sentence investigation report at least 2 days before the sentencing hearing. I would only proceed today if you're willing to waive that right and continue.
Yeah, I'll wait.
All right. Are you satisfied with Mr. Eggers and the advice that he's given you?
Yes.
Did you have an opportunity to discuss the report with Mr. Eggers?
Yes.
Do you wish to explain or challenge the accuracy or relevancy of any of the information that's in your pre-sentence report?
Your Honor, I do have a couple.
Okay.
Very small. It relates to the first page as it relates to jail credit. The report lists that as 0 days. That's obviously incorrect. At the time we had previously scheduled for sentencing on the 31st of January, I had the calculation as 1,050 days. That was based on a total of 596 days passing from the original sentencing on June 16th, 2023, plus the 454 days of jail credit he received at that time. Since obviously the 31st, an additional 21 days have passed, so I believe the correct number of jail credit at this time is 1,071 days.
Okay, Ms. Wise, do people agree with that?
I have no objection. I didn't calculate the jail credit.
That same issue appears on page 3. Here they list the total days of jail credit is 939. As the court can see, the dates that are listed on the credit only go to November 1st of 2024. Obviously, we are here on February 21st, so it has the same change, the change of the date to the February 21st, 2025 date and the 1,071 days of jail credit as opposed to the 939 listed.
Ms. Wise, any issue there?
No objection.
Okay, so we will make those corrections.
And those are the changes I had, Your Honor.
Okay. Ms. Wise, do people have any corrections to the pre-sentence investigation report?
As far as the PRV, the guidelines themselves, or just the report?
Just the report.
No, Your Honor.
Sir Eggers, does the pre-sentence investigation disclosing prior convictions in which there existing known constitutional defects?
Not to my knowledge, Your Honor.
the probation officers calculated minimum sentencing guidelines on the second-degree murder charge to be from 315 to 525 months or life. Ms. Wise, do you agree with that computation of guidelines?
I do not. The upper end with his habituals should be, well, I would argue 1,200 on the top end, but I believe the way that she has them scored, they would be
It'd be
1050, 1050.
Okay, just so I'm clear, you agree that the PRV number is correct and the OV number is correct, but the spot on the grid was wrong, or do you?
No, I'm still challenging a few of the PRVs.
Okay, what's the prior record variable that you challenged?
PRV 1. Or get a copy of our memo.
Yes, I did.
Okay.
And then I also submitted a memo of that.
Yes, I received this as well. I'm sorry. Give me just one moment.
Okay.
Okay, I have read those memos. Is there anything you want to say about PRV one?
The only addition, after getting Mr., is it Eager or Eggert? I'm sorry.
It's accurate.
Eggert, after getting Mr. Eggert's response, I would just add as to the ex post facto issue, we are not trying to increase the penalty for his previous offenses. At the time the defendant committed the instant offense, which is the homicide conviction from 2018, 2019, he would have been on notice that the severity level of the prior convictions had changed. He would not be subject to an increase in severity had he never committed a new crime. I would indicate to the court that I believe that's akin to People v. Perkins, 280 Mich. F. 244. In that case, that dealt with OWI and prior convictions, but the courts held that all ex post facto laws share two elements. They attach legal consequences to acts before their effective date, and they work to the disadvantage of the defendant. In this case, the law certainly works to the defendant's disadvantage, but the amendment did not attach legal consequences to their prior offenses, which occurred before the amendment's effective date. Rather, the amendment made the consequences of their current offense, which occurred after the certain date, more severe on the basis of his prior convictions. So I would indicate there is no ex post facto issue in scoring PRV. 75 points, Your Honor.
Okay, Mr. Eggert.
Well, Your Honor, I do disagree with that. I think one of the things to address here is that the guidelines, in effect, at the time the alleged offense takes place, dictate the scoring of the guidelines, and that applies to the prior record variables and what they were categorized at the time the offense took place. That's why in the back of the guidelines manual, where the alphabetical and numerical statutory list still list the offenses even after they're amended and the effective date. That's to allow the court and the pre-sentence report writers to look at the time this offense took place and score it appropriately based on the date and time of the guidelines in effect at the time of those offenses. I'm unaware of this, the Jenkins case cited by the prosecutor, but I do believe this has the effect of escalating the punishment related to those prior offenses by categorizing it in a higher prior record variable than would have been permitted at the time those offenses were committed.
Okay, convictions 4 of 10, 5 of 10, and 6 of 10 in the criminal history all include discharging a weapon in or at a building pursuant to MCL 771.16M. That is a Class D felony. Therefore, those are prior high severity felonies, and 75 points is appropriate. MCL 769.34 subparagraph 2 requires that the court use the sentencing guidelines in effect at the time of the offense in sentencing for that offense. This is not sentencing the defendant for the 2001 and 2002 offenses. It is sentencing him for the 2018 offense under the guidelines in effect at the time of that 2018 offense. Those guidelines classify discharging a weapon in or at a building as Class D felonies. Sentencing today is for the 2018 crime, again, not for the 2020, 2001 or 2002 crimes. PRV 6 does not increase the punishment of defendant's former crime. Affects the punishment of the crime committed after the statute was amended. So I would agree with the prosecutor that 75 points is the appropriate score. PRV 1, and that would be the score to 75. And PRV 6 was your next.
Yes, Your Honor. The argument here is that the defendant was in jail at the time the offense was committed, and I would indicate the appropriate score based on PRV 6, score 15 points if the offender is incarcerated in jail awaiting adjudication or sentencing on a conviction or probation violation. I believe it's currently scored at 10 points, and I would ask the court to score it at 15.
Mr. Eggert.
Your Honor, as the courts where I've objected to this variable, I believe it's appropriately scored at 10 points as Mr. Trevino was on parole at the time. The 15-point score doesn't contemplate the situation where someone is on parole. That's a distinct situation there, and I believe that 10 points is appropriate.
Okay, the evidence at trial clearly established that Mr. Trevino was incarcerated in the Lenawee County Jail at the time that he first solicited Austin Richardson to kill Christopher Dickerson. However, it's also clear that he was incarcerated on a parole detainer at that time. PRV 6 is scored at 15 points where the offender is incarcerated awaiting adjudication or sentencing on a conviction or probation violation. That by express language does not include the situation where someone is being held on a parole detainer. So I don't think that 15-point score would be appropriate. I think 10 points is the appropriate score. Okay, and then Ms. Weiss, OV8 was your next issue. Is that?
I did not.
That was
Your Honor. I apologize. Okay, go ahead, Mr. Eggert, please.
The argument here is fairly straightforward. OV8 doesn't account for scoring of conduct of co-defendants. It only accounts for Mr. Trevino's actual participation in the charged offenses, and his conduct did not involve aspiratation. So the appropriate score should be 0.
I have researched that, and I would agree with Mr. Eggert.
Okay. Court had an opportunity to look into that as well, and I would agree with both counsel that Mr. Eggert's argument is accurate, and the appropriate score then would be 0.04. Then I think OV13 was the last one.
Yes, Your Honor. The argument here is essentially there's an absence of a pattern. That's a 5-year period where there's at least more than the offense alleged here. And I believe that the evidence here does not establish such a pattern. Although the evidence could show a crime that was gang related, as the convictions would reflect, that single conviction is not enough to establish a pattern. Also, I did note that his other conviction of gang membership is a crime against public order, not a person. So I believe the appropriate score, as opposed to the 25-point score here, would be 0.
Ms. White?
Okay.
Okay. I would agree as well, that only conviction 9 of 10 fell within that 5-year period. Were there any other challenges? I think that was all from.
No, Your Honor,
Those were, that was the remainder of my challenge.
Okay. And so if I did the math correctly, then total prior record variable score would be 147. The total offense variable score would be 105. That would be PRV level F, OB level 3, which would result in minimum sentencing guidelines being 365.
That's correct, Your Honor.
that's correct, I would agree.
Okay. All right then. Before the court passes sentence, Mr. Eggert, is there anything you'd like to say on behalf of Mr. Trevino?
Yes, Your Honor. I know the court's very well of this case and has reviewed my memo, so I won't take too much of the court's time explaining this. But I think one of the things that's significant, that's a difference from the time of the initial sentencing and the sentencing here, is the change in the charges that are at issue. And also, I think it also reflects the nature of the charges that are issued. And I specifically referenced the case of People versus Beck in my sentencing memo, and that relates to the use of acquitted conduct. And here it's not only the premeditated murder that Mr. Trevino was acquitted of, but the offenses that he was also, at the time of the initial sentencing, convicted of, which involved the conspiracy to commit second-degree murder and the solicitation of murder, of second-degree murder, are not offenses as a matter of law. And the conduct of conspiracy, solicitation, premeditation is something that Mr. Trevino has been acquitted of. It's not something that's an appropriate basis to sentence him based on Beck. There's a very clear due process right to not be sentenced based on acquitted conduct. And I believe a lot of the reasoning used at the time of the initial sentencing, as I highlighted in the memorandum, dealt with conduct that he was effectively acquitted of at the time. And given the change of circumstances here, his age, as I mentioned in the memo, he's currently sentenced to a minimum of 45 years. That would make him 84 years old at the time he is released. That's a de facto life sentence in the Michigan Department of Corrections. The average life expectancy is certainly not 84 years old. I believe that there is a 25-year mandatory minimum sentence here at play that would be appropriate and essentially place him at the same age as the studies performed by the United States Sentencing Commission show that recidivism substantially drops when an individual is in their 60s. Mr. Trevino would be in his 60s. And I do believe that considering Milborn a 25-year mandatory minimum sentence is sufficient but not greater than necessary to address the punishment.
Thank you. Mr. Trevino, is there anything you'd like to say on your own behalf before the court passes?
No, sir.
Ms. Wise, do people wish to?
Your Honor, Tracy Dickerson wishes to address the court at this time.
Good morning, Your Honor. Thank you for allowing me to speak again today. I'd first of all like to thank everybody that has gotten these monsters off the street. For my son. I really thought all of this was behind us. But that would be wishful thinking. There's always gonna be appeals, parole hearings, and whatever else they decide to use the taxpayers' money for. This person doesn't deserve any of it. I hear life sentences. Your Honor, the only one that got a life sentence was my son. He comes in here, with a big old smile on his face, like he's going to a birthday party. There's no remorse. He doesn't care about my son. He doesn't care what happened to my son. I do. But I'd like to tell you today, Your Honor, I'm in a much better place. I actually celebrated Christmas this year with my family. We did all the things. We did cookies, we did presents. I enjoyed it all. I am looking forward to making so many more traditions and making memories. I'm at peace now. I will always hurt for Chris immensely. But I also know he is at peace now. And now that all these monsters are in prison, Your Honor, this person is never going to stop hurting people. Whether he's in prison, he's out, it doesn't matter. And I'd just like you to think, whether he's 65, 85, he's not gonna change. He's gonna get worse. With his prior record, honestly, he shouldn't have even been out to have made this happen to my son. I have so much more to say, but Your Honor, all I can say is, don't let this person ever get out. Don't give him a chance to ever get out. I don't want another family to go through what I'm going through. That's all, Your Honor. Thank you.
Defense asks you not to use acquitted conduct to fashion a sentencing, which I agree, the court can't do that. However, this court sat through weeks of testimony, sat through the trial, heard all the testimony. The guidelines are 365 to 1,200 months. I'm not good at math, but I believe that's 100 years on the top end of the guidelines, Your Honor. As well as the fact that the gang charge could be stacked if this court wished to do that. And the prosecutor's office has requested that. However, this court fashioned a sentence that they believed was appropriate. I would ask the court to continue the sentence that this court imposed the last time, as that would be an appropriate sentence. Yeah.
This is a resentencing, obviously. And at the time of the initial sentencing, we did ask the court to consider consecutive sentencings. And I'm going to approach it from that perspective briefly here. This is the time that Mr. Trevino was convicted was sentenced back on June 16th of 2023. A few things have happened. The Court of Appeals vacated 2 of his convictions on jury instruction and issues and other technical grounds. And maybe more importantly, Andrew Cecil pled guilty to manslaughter and felony firearm charges. In his factual basis for his guilty plea, Cecil verified in summary a great portion of what Austin Richardson testified to during his trial testimony and his preliminary examination testimony. And without explicitly naming Mr. Trevino in any capacity whatsoever. But certainly Mr. Trevino's jury spoke to all of us, Ms. Dickerson, the court, et cetera, on that particular issue. And this court, when it sentenced Mr. Cecil, did speak on the issue of consecutive sentencing with very sound and solid logic and, frankly, Judge, genuine eloquence. You indicated that Cecil's desire to prevent Dickerson from testifying in the assault case was an attempt to subvert the judicial system. You stated, quote, "In this case, it's particularly true where we have a justice system that is designed to try to find the truth when charges are made. And in this case, Christopher Dickerson was murdered in an attempt to hide that truth. Along with the attempted harm to the judicial system, you indicated that the consecutive sentences were appropriate for Mr. Cecil because both cases involved the same victim." Now, I have personally stated before in this court that it was Andrew Cecil who lit the fuse that directly resulted in the murder of Chris Dickerson. But it was Count Teresa, the almighty Trevino, who figuratively provided the fuse, the matches, and the manpower to cause this murder to come to fruition. Amongst Mr. Trevino's 11 prior felony convictions and 5 prior misdemeanor convictions are convictions involving shootings and witness intimidation. And while it is 100% true and accurate that Trevino was nowhere near the original assault of Dickerson, everything that happened thereafter, everything that led to Dickerson's murder belongs to Trevino. He owns this murder. Proudly. Make no mistake, the murder of Chris Dickerson simply does not occur without Mr. Trevino's consent, approval, and advice. He directly and materially aided and abetted this murder. Our legislature has given courts a tool, the ammunition it needs to make a true statement of deterrence when consecutive sentencing is appropriate. As the leader of the local Latin Count gang, Trevino's actions fits squarely into the scope of the legislature's intent. We still absolutely believe, Ms. Dickerson, Ms. Wise, myself, law enforcement, that consecutive sentencing is not only appropriate, it's justified. We already know that Tracy will never forget Chris, but once and for all, let's make sure that Count Teresa, the almighty Trevino, doesn't forget him either. Thank you.
In determining the appropriate sentence in the case, the court has considered the seriousness of the offense, your history, principle of proportionality, the statutory penalty, the cost of confinement, the report and recommendation of the probation department, as well as what's been said on the record this morning. The criteria and reasons for the sentence are the nature and gravity of the offense, the discipline appropriate to its commission, deterrence against repetition by you and by others, vindication for the law, and the protection of society. Mr. Trevino is 41 years old. He has 11 prior felony convictions and 5 prior misdemeanors. He has a juvenile adjudication for arson. He has 3 convictions for discharging a firearm in or at a building. He has a conviction for felonious assault, a felony firearm conviction, a bribing, interfering, or intimidating a witness conviction, conviction for assaulting a prison employee. In 2016, Mr. Trevino was convicted of accessory after the fact to a felony. He violated his parole numerous times and was pending a parole violation at the time that he committed these offenses, second-degree murder and gang membership felonies. The only rational conclusion from Mr. Trevino's criminal history is that he is an assaultive, extremely dangerous person who poses a serious risk to the public, is not interested in rehabilitation. His prior record variable score is 147. That's 3 points shy of being twice what it takes to reach level F, which is the highest level on the M2 grid. He's been placed on probation and violated. He's been given 8 prior prison sentences and committed an additional felony while in prison. He was paroled, violated, and then committed this offense. He's been undeterred by previous sentences. Other than obtaining a GED while in prison in 2002, the record before the court contains little, if any, evidence that Mr. Trevino has done anything to rehabilitate himself. The nature and gravity of these offenses, particularly the second-degree murder conviction, could hardly weigh heavier in favor of a strong punishment than they do in this case. What's more serious than, or more grave than murder? Nothing. And when we compare this second-degree murder to other situations that also constitute second-degree murder, this ranks at the more heinous and perhaps most heinous end of that spectrum. This one occurs in the context of a criminal gang enforcing its rules and preventing a person from testifying in a criminal case against another member. That is the evidence in this case, and it implicates more than just a loss of Christopher Dickerson's life, which is the ultimate tragedy. It harms societal safety, it creates fear and anxiety in the community as a whole, and it injures the ability of the justice system to function. And those factors make this case far more serious than most second-degree murders. A 25-year sentence is not proportionate to the intentional killing of a 26-year-old young man who had far more than 25 years left to live. 25-year sentence is not proportional to the criminality that took place in this case. It's not proportionate to a young man being walked into the woods, shot in the back, and left to be fed upon by wild animals. 25-year sentence is not proportional to a person who has had numerous opportunities to rehabilitate before being convicted of murder. 25-year sentence is not proportionate to a murder that occurred to enforce gang rules and prevent a witness from testifying in court. The original sentence given on this second-degree murder count was 45 years, and I believe that is far more proportionate and is proportionate to the offense that occurred, which, as I've discussed, has had more aggravating factors than any second-degree murder that I'm aware of. And it's also more proportionate to the offender, who has an extreme criminal history and who has rejected all prior attempts to rehabilitate himself. Indeed, as Ms. Wise said, the upper end of the minimum guidelines is 100 years, and a 45-year sentence is less than half of that. As a result, I believe that every day of that would be proportionate to the offense that occurred in this case and the offender who committed that offense. With respect to count 1, second-degree murder, it's a sense of the court that Mr. Trevino served 45 to 85 years with the Michigan Department of Corrections. Must pay restitution in the amount of $2,490.40 to Tracina Dickerson. Must pay $130 crime victims assessment and a $68 state cost. With respect to count 4, the gang membership felonies, it's a sense of the court that Mr. Trevino served 10 to 20 years with the Michigan Department of Corrections. You must pay a $68 state cost. As I said at the first sentencing, and I continue to believe here today, I think that concurrent sentences are appropriate given the nature of the sentence on the second-degree murder charge. And so I will continue to run those sentences concurrently. Mr. Trevino, you have the ability to request an appeal of your sentence. The bailiff is going to hand you 3 copies of the notice of right to appellate review and request for appointment. To sign 1 copy of that form and return it to us. Just indicates that you received your copies of those forms. you want to appeal your sentence, you need to fill out the remaining portion of that form and mail it to the address listed in the form within 42 days. Or if you know now that you want to fill that out, we'll give you an opportunity to do that before you leave the courthouse. I record should reflect that I do have a copy of the notice of appellate rights form and placing that, and signed by Mr. Trevino, and I'm placing that in the file.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you, Your Honor.
Okay, the gentleman at the jail, you're Mr. Dunsworth?
Yes, sir.
Okay, this is file 25-22148-FH. Okay, this is file 25-22148-FH, People versus Jacob Lee Dunsworth. We're here today for an extradition hearing. We are proceeding today by video conference. Sir, you're Jacob Lee Dunsworth? Sir, are you Jacob Lee Dunsworth?
Yes, Your Honor.
Okay. Mr. Dunsworth, this is a proceeding to determine whether you wish to waive your rights to extradition. Extradition is a proceeding to return you to another state in which a warrant has been issued for your arrest for the commission of a felony. It is in effect a demand by another state for your surrender to return to that state to face the charges with which you've been charged in that state. You've been charged in Fulton County, Ohio, with the offense of felonious assault, which is a felony in the state of Ohio. We cannot, in this court or in this state, determine the truth or falsity of the charges made against you in the state of Ohio. You do not have to waive your right to extradition. You can require the governor of the state of Ohio to make a demand upon the governor of the state of Michigan for a warrant for your extradition. You have the right to demand and procure legal counsel. If you cannot afford an attorney, the court would appoint one for you at public expense. If you or your attorney wish to test the legality of your arrest, you can apply within a reasonable time for a writ of habeas corpus. That's a writ by which your custodian is required to bring you before the court for the purpose of having a hearing to determine the legality of your arrest. Do you understand those rights, Mr. Dunsworth?
Yes, Your Honor.
Do you want to be represented by an attorney at this time?
Yes, Your Honor.
Do you have the ability to pay for your own attorney?
No, Your Honor.
Okay, if you sit tight there for a minute, we will have our public defender get logged in. I've got to take care of one other hearing first. Ms. Underwood? Ms. Underwood,
Yes,
can you stay here? And I've got Mr. Cranker here from Ohio now, so let's do him
I was
first.
gonna go down and get on the,
Oh, okay. All right, so Mr. Dunsworth, I'm going to do one other hearing first, and then I'll have you talk to Ms. Underwood, okay?
Yes, Your Honor.
All right, Mr. Malero, are you ready to proceed with Mr. Satterla in the meantime?
Yes, we are.
Okay, this is file 24-22009-FH, People versus Arnett Satterla III. We are today for a pretrial conference in this case, and we're proceeding today by video conference. First, can I have the attorneys place their appearance on the record, beginning with Mr. McCready.
Good morning, Your Honor. Dave McCready for the people.
Salvatore Malero on behalf of Arnett Satterla.
All right, so where do we stand with Mr. Satterla today?
Your Honor, I think we've resolved the confusion in this case. Mr. Satterla is going to plead as charged, no contest. And then I suppose we'll discuss and debate the issue of sentencing. There has been no sentence agreement. The basis for Mr. Satterla's no contest plea is twofold. First is civil liability, and the second is lack of memory due to the nature of the incident itself.
Okay. Mr. Satterla, would you raise your right hand, please? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty of perjury? And I need you to speak a little bit louder than that so we get your voice in the recording.
I do.
Thank you. You are Arnett Satterla III?
Yes, sir.
Mr. Satterla, you've heard the statement of your attorney in the prosecuting. Well, I'm sorry, Mr. McCready, I didn't ask you, is that a complete and accurate statement of the plea?
It is, Your Honor, yes.
Okay. You've heard the statement of your attorney and the prosecuting attorney, Mr. Satterla. Is it your intention to plead no contest today to operating while intoxicated causing serious injury?
Yes, sir.
You understand that the maximum possible penalty for that offense is up to 5 years in prison and or a fine of $1,000 to $5,000.
Sure.
It's also your intention to plead no contest today to count 2, which is a second count of operating while intoxicated causing serious injury.
Yes, sir.
Do you understand that that has the same maximum possible penalty of up to 5 years in prison and or a $1,000 to $5,000 fine?
Yes, sir.
Neither prosecutor, defendant, or anyone acting on the defendant's behalf has discussed a possible sentence with the court other than we have had discussions about Cobb's evaluation, which did not result in any agreement. Is that correct, Mr. McCready?
That is correct.
Mr. Malero?
That's correct, Judge.
Is that also your understanding, Mr. Satterla?
Yes, sir.
If a guilty plea is accepted, Mr. Satterla, there'll be no trial. That means you're giving up the rights that you would have had at trial. And explain those to you now to make sure that you understand. You do have the right to a speedy public trial by jury. You could ask for a non-jury trial, and if the prosecutor and the court agree, you could have a non-jury trial. You have the right to be presumed innocent or guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at your trial, to have the witnesses against you appear at your trial, and to ask those witnesses questions. You have the right to have the court order any witnesses you have for your defense to appear at your trial. You have the right to remain silent during your trial and not have that silence used against you. However, you also have the right to testify at your trial if you wanted to testify. Do you understand that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at a trial?
Yes, sir.
Do you also understand that any appeal from the conviction and sentence pursuant to your plea would be by application for leave to appeal and not by right?
Yes, sir.
If you are not a citizen of the United States, conviction of a crime can result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about any of those rights?
No, sir.
You understand that you're giving those rights up?
Yes, I do, sir.
How do you wish to plead to the charge that on or about April 13, 2024 in Rome Township, Lenawee County, Michigan, that you did commit the offense of operating while intoxicated causing serious injury?
No contest.
And how do you wish to plead to the charge that again on or about April 13, 2024 in Rome Township, Lenawee County, Michigan, that you did commit the offense of count 2, operating while intoxicated causing serious injury?
No contest, sir.
Has anybody made any threats or promises to you to induce you to plead guilt, not to plead no contest to those charges?
No, sir.
Do you understand that if I accept your plea, you're giving up any and all claims that your plea was given as a result of threats or promises that were not disclosed to the court on the record this morning, or that it was not your own choice to enter the plea?
Yes, sir.
Is the prosecutor or defense counsel aware of any promises, threats, or inducements other than the plea bargaining, but to induce Mr. Sadler to plead no contest?
Well, I think it's sort of an inducement, Your Honor. He was approved for Veterans Court, although that's not a given. And he understands.
Okay, Mr. McCready?
I am not aware of anything like that, no.
Okay. Mr. Sadler, has your attorney promised you any particular sentence or estimated what your sentence would be?
No, sir.
Is it your own choice to plead no contest today?
Yes, sir.
All right. How are we establishing the factual basis?
I try, Judge. So, Your Honor, we believe.
Go ahead.
Your Honor, we believe that this matter would have gone to trial. The state would have been able to prove beyond a reasonable doubt as to both counts 1 and 2, as both of the injured persons were in the same vehicle at the time of the collision. That in Rome Township in the county of Lenawee in the state of Michigan on or about April 13th, 2024, that Mr. Sadler was operating a motor vehicle on Onstead Highway, and at the intersection of Onstead Highway and 223, Mr. Sadler ran through a stop sign and collided with an ambulance being driven by one of the parties named in the information. And there was also a patient being transported, and that those both parties sustained serious injuries, as well as Mr. Sadler, based on the probable cause affidavit. Mr. Sadler did admit to the officer investigating the incident that he had consumed some alcohol, and that there was a blood draw which resulted in a 0.16 BAC. But that Mr. Sadler does not recall the collision itself, and only recalls being at the American Legion and then waking up in the hospital. We believe the state would be able to prove that beyond a reasonable doubt, and that would satisfy all the elements of both counts of the information.
Okay, Mr. McCready, are the people satisfied with the factual basis?
I just would add that the driver of the ambulance was Ronald Wyant, and he suffered extensive injuries, including a broken collarbone. He's been out of work for almost a full year. Also, the patient in the ambulance was William Joseph Dressel. He was not in critical condition in the ambulance, but as a result of this crash, nearly died and has suffered serious injuries as a result. So we just want to make sure that was part of the record.
Mr. Miller, you agree with those facts?
Yeah, we have no objection to those as stated by Mr. McCready.
Okay.
With that, I'm satisfied, Your Honor.
Okay, thank you. Has the court complied with MCR 6.302 B, C, and D, Mr. McCready?
Yes.
Mr. Miller?
I believe the court has.
All right, I will accept the plea then. It's been given understandably, voluntarily, and accurately. Mr. Sadler has had full knowledge of his rights, and he has had confidence. The court has not made any agreement regarding the possibility of a plea or sentence in this case with the prosecutor, defense attorney, defendant, or anyone acting in the interest of any of them. I will refer this matter to the probation department for a pre-sentence investigation and set sentencing April 3rd at 8:15. Mr. Sadler, someone from the probation department will be in touch with you to do a pre-sentence investigation interview. when you do that interview, please be truthful about these offenses and about your background. Should he just step across the hall and pick up his packet?
Yes, please.
Okay, so if you'll step across the hall to the probation department, you can pick up a packet of information that you need for the pre-sentence investigation process.
Thank you, Judge.
Thank you.
Thank you, Your Honor.
Thank you, sir.
Thank you. Mr. Dunsworth, while we're waiting, have they provided with copies of waiver forms in case you want them?
The waiver of extradition forms?
Yes.
Yes, sir. Yes, Your Honor.
All right, don't do anything with them yet. I just wanted to make sure you had them in case they can become necessary.
Okay, thank you, Your Honor.
You know, every 40 or 50 years, we should get new chairs.
No kidding.
Here you go, I on my note for some reason, so.
Oh, really?
Hey, are you covering her?
Are they waiting for me? Or I thought Becky was gonna start it and I told him I'd be down between 9:30 and 10.
I just wonder.
Oh, yeah.
They're waiting, Mary.
Oh, okay.
They're handling non-record matters while we're waiting, so no worries.
Oh, okay. Thank you.
Someone's always listening.
Yeah. To prison in Ohio. So they're sometimes on tight schedules, so I'd like to get them while we have them.
Is it prison in Ohio?
It was Rhonda.
She's talking to Mr. Clinton in the breakout room right now. his conviction in Ohio came after this conviction. Is that accurate?
Yeah, so it's number 4 of 5.
Yeah.
He actually pled to that on 4/3 of 24. So, these are 1, 4. So yes. And same thing with number 5 of 5. You guys will appear down there as well. After that. For 7 weeks.
You know, concurrent or consecutive.
Is our concurrent.
Hey,
How are you? Good morning.
you good?
I'm good. How are you?
Okay, this is file 23-21391-FH, People versus Zachary Richard Cranker. We are here today for sentencing on a probation violation. And we are proceeding today by video conference. First, Ms. Underwood, would you like to place your appearance on the record?
Rhonda Underwood for Mr. Cranker this morning, Your Honor. Thank you.
Yeah, I apologize. There is also a sentencing out of contempt of court for failure to appear at a show cause hearing. And sir, you are Zachary Richard Cranker?
Yes, I am, sir.
Mr. Cranker, have you had an opportunity to read and review your probation violation recommendation report?
Yes, sir, I have.
Have you had an opportunity to discuss that with Ms. Underwood?
Yes, I have.
Are you satisfied with Ms. Underwood and the advice that she's given you?
Sure, yes.
Do you wish to explain or challenge the accuracy or the relevancy of any of the information that's in your recommendation report?
Sir, I just wanna start by saying that if I got dates wrong, back when my dad passed away and with sentencing and stuff, I apologize. But the way that I wrote you a letter and how I wrote it and what I said came from my heart, sir, and that's really how I felt. I don't know how I got my dates wrong, but that's how I remember it. Because why would I'm not trying to make excuses.
I believe
And
Mr. Cranker is going to Ms. Walsh's allegations in the recommendation, Your Honor. And he
Okay,
would
so I'm
he
sorry.
would just like to say that he in no way meant to manipulate the court or to, he genuinely made a mistake.
Okay. Is there any other information that you want to challenge the accuracy of?
I don't believe he does.
Okay.
no,
All right. Before the court passes sentence, Ms. Underwood, is there anything you want to say on behalf of Mr. Cranker?
Absolutely, Your Honor. Your Honor, Mr. Cranker understands that he did the completely wrong thing, not showing up at jail. I will say, I think at the time, Mr. Cranker was dealing with a lot, including the death of his father, Your Honor. Your Honor, I think understands he's in jail, he's in prison in Ohio. He understands that he should have complied and come here and came in. I do think that the fact that we have him now and he's here ready to do his time benefits everyone. I would ask the court, I understand from Mr. Cranker that this was originally going to be a no upfront jail case. And that changed its sentencing. And the 9-month jail term was given. I would ask the court humbly to consider allowing Mr. Cranker to have some credit for the time he's doing in Ohio, Your Honor, and not make the time all consecutive. I believe that that would be appropriate in this case. Thank you so much.
Mr. Cranker, is there anything you'd like to say on your own behalf before the court passes sentence?
yes, sir, like I said, I just want to apologize for any if I didn't mean to mislead you or try to make excuses for anything. I just honestly, I've had a rough last couple of years, my dad being sick, and then he passed away, and at the same time, my wife, her mom was battling cancer, and the same thing at one time, they was in the same hospital on the same floor, and she passed away a month after my father did. So it's been really rough for us lately. And I just asked the court if they can please help me. I'm 37 years old, and I feel like I wasted a lot of my first half of my life. And I have a 20-year-old daughter, a 17-year-old stepdaughter, a 12-year-old stepdaughter, and a 10-year-old daughter. And I just want to I just want to show them that I'm a good father and provide for them and be a good husband and live my life right and continue with working and providing for my family and doing the right things. I just ask that you help me and so that I can do that. Cause my family needs me bad. My 20-year-old daughter just a month ago got beat up by her boyfriend and ended up in the hospital. We lost a baby before I got incarcerated. We lost our house, lost my dad, lost my mother-in-law. I've lost so much. And I just want to do the right things and get back to my life, sir. Please. Thank you. I'm sorry.
Okay, so this is a case where Mr. Kranker was originally placed on probation and given a 9-month jail sentence total by April 26, 2024, and did not. After he pled in this case, he was convicted in Ohio, serving a sentence in Ohio for those convictions. So I guess I would say, Mr. Kranker, that, you know, the court in placing you on probation has tried to help in the way that the court can. So the options that the court has in terms of sentencing are to incarcerate someone or place them on probation and use the resources of probation to help rehabilitate someone. But the court and the probation department can't do 100% of that work. You know,
I understand that, sir.
you have to do the helping too. And you have to do most of it. And you have to take advantage of the opportunities and the resources that exist in order to do that. And in this case, you didn't. I appreciate that you had a lot of difficult family circumstances that in your mind caused you to do this, but from my perspective, we can't assign people to probation and just not have them participate at all. You have to do the things that the probation requires. And that didn't happen here. The recommendation here is to serve the original 9-month jail sentence and be continued on probation. With respect to the concurrent or consecutive issue, as I said, Mr. Kranker is serving a sentence for a conviction that occurred after this conviction. I don't know of any legal basis that would allow me to make the sentences consecutive. And so I think they have to be concurrent. So that's what I'm going to require at this point, that you serve the original 9-month jail sentence that would be concurrent to your sentence in Ohio. And the violation or arrest date is 1/16/25. So you would have 36 days of credit related to that sentence. So again, sentence of court that you serve the original 9-month jail sentence that you have 36 days of credit, and that you be continued on probation at the conclusion of that sentence. You do have the ability, Mr. Cranker, to request an appeal of your sentence. We're going to send to you 3 copies of the notice of right to appellate review and request for appointment of attorney form. When you get that form, you need to sign 1 copy under the receipt of notice heading. That just indicates you got your copies of those forms. If you want to appeal your sentence, you would need to fill out the remaining portion of that form and mail it to the address listed in the form within 42 days. Do you understand that?
Yes, Your Honor.
Okay. We are all done for today. Then you can let the officer with you know that you're done with court.
So essentially, then if he's done there early, he would be moved here.
Correct. I would assume that would be the process.
Okay. So did you understand that, Mr. Cranker?
Yes,
And then when you're released here, you need to report immediately to my office.
of course.
Okay. I think we're all set then. You can let them know that you're done, Mr. Crank.
Thank you.
Your Honor,
Okay. Yeah.
and just to make sure I understand, he is serving that sentence now.
Correct.
Thank you. Thank you.
Okay. Mr. Dunsworth, thank you for your patience. I'm going to put you in a breakout session with Ms. Underwood right now.
Thank you, Your Honor.
Can we get Kevin for judge? Then we can, great thing. Well, between him and
Dunsworth.
yep, after those 2, then judge will say.
Everything else you need, Judge? Things like else covered?
Let's see.
Or no, Chris Jones has.
Yeah, Chris has got Kevin Berlindi, so we're all set.
Is he on?
He's on, yeah.
Okay,
He's on, you just can't see.
thank you.
There he is.
Judge, do we have Matthew Smead as well?
I do not have him on my docket. He doesn't sound familiar. Is he mine or Antoine's?
It says you. I thought I saw it on the docket. I'll have to double check. It's fine if it's not. I thought maybe we already did it, but I'll double check. He's not on there, so I am good.
Okay. Okay, we are back on the record in file 25-22148-FH, People versus Jacob Lee Dunsworth. Ms. Underwood, would you like to place your appearance on the record?
Rhonda Underwood for Mr. Duckworth this morning, Your Honor. Thank you.
And do you know how Mr. Dunsworth would like to proceed today?
I've explained the situation to Mr. Duckworth And Mr. Duckworth wishes to forego requesting that the governor do a warrant, Your Honor. He wishes to waive his right to habeas corpus and sign the documents necessary for him to go back to Ohio.
Okay. Mr. Dunsworth, do you want to waive your right through extradition to a writ of habeas corpus and go voluntarily to the state of Ohio to face the charges that have been made against you there?
Yes, Your Honor.
All right, then please sign those waiver forms that they've given you under the heading waiver about the middle of the page there. And you need to sign each one of them. Okay, have you signed all of those?
Your Honor.
Do you swear that the signing of those waiver forms is your own free act and deed for the purpose of waiving extradition?
Yes, Your Honor.
Okay, so they will bring those over to me from the jail. There's the certification section that I'll sign. I'll get those signed today, and then the jail will let Fulton County know that they can come and pick you up.
Okay. When can I expect to have court?
It just depends on when they come up and get you, and then the Ohio process takes over from there, and I don't have any way to tell you what that might be. So you can let the officer that's with you know that you're done with court for today.
Thank you, Your Honor.
Okay, Ms. Underwood, you need to speak to Mr. Verlinde.
Yes, thank you, Your Honor.
Okay, Ms. Underwood, are you ready to proceed?
Yes, Your Honor.
All right, this is file 23-21604-FH People versus Kevin Ryan Verlinde. We are here today for a hearing on a probation violation, and we're proceeding today by video conference. Ms. Underwood, do you want to place your appearance on the record?
Rhonda Underwood for Mr. Verlinde this morning, Your Honor. Thank you.
Okay.
I've discussed this matter with Mr. Jones again, Your Honor, and charges were brought. So I feel constrained in this matter that I have to continue the not guilty plea and would request that the court reconsider bond in this matter, Your Honor. Mr. Verlinde doesn't go anywhere. He's available to the court. We are compiling his records from Pine Rest, Your Honor. They have got them available for us. We just need to get them to us. And now this may be some time before this matter is resolved. I would hope the court would consider a bond in this matter with whatever reporting Mr. Jones wishes. And it would allow Mr. Verlinde to take care of the other issue.
Mr. Jones, anything input you'd like to have regarding a request for bond?
Judge, I'm sure you're aware, we've already discussed this previously. I don't have much more to add. Nothing's changed from the last time we had this discussion, other than now he has a new felony or a new charge for the same thing of failure to register or verify the registration. I also would note, Judge, the court at the original sentencing on April 12th of 24, Mr. Verlinde's guidelines were 10 to 23, and the court downward departed and did a 10-month jail sentence suspended. So I think in all those facts, I think it would just be appropriate to continue the same bond and then go forward from there.
I was in a mental hospital.
Your Honor, I do think it's important to note there's been no allegation of any untoward behavior. This is an allegation of noncompliance where I believe it's clear my client was in and out of a mental facility at the time. And while technically I don't believe this was a case of willful noncompliance with the court's orders. So I would hope the court would at least consider bond and allow us to get this properly resolved.
My plan is to go back to the mental hospital, whether after all this is done and said anyway, sir.
All right, what I'm willing to do at this point is GPS tether bond. So I would allow a PR bond with GPS tether at this point.
Thank you, Your Honor.
Thank you, sir.
All right, do you have any idea when does he have any kind of hearing coming up in wherever it is the new charges
I
are?
suspect either they will take him on the warrant, Your Honor.
No.
Yeah, I would suspect that will happen if he gets a tether.
Okay, let me set this then for a pretrial conference on March 19th at 8:15.
Thank you, Your Honor.
Thank you.
All right, I think we're all set for today then.
I believe that completes my docket with you this morning, Your Honor.
Yes, thank you.